Tonight, we turn our attention to a swiftly developing and gravely significant matter at the intersection of legal accountability, executive authority, and the institution of the American presidency. Recent filings and emerging accounts are sparking deep concern and broad discussion this evening. Are agents from the United States Marshals Service ready to remove former and now current President Donald Trump from his Mar-a-Lago property in Florida over unresolved court-ordered financial penalties? To be direct, developments are unfolding rapidly, and reliable verification from government sources is still limited at this hour. That said, if the emerging details prove correct, this would represent an extraordinary event with few parallels in contemporary American history. Sources familiar with the related legal matters, spanning civil penalties and other proceedings, have confirmed that federal authorities hold long-standing statutory power to enforce collection against assets when judicially mandated payments go unmet. Mar-a-Lago, long regarded by the president as the flagship of his portfolio, has functioned as both a personal residence and a central venue for political gatherings and strategy. Right now, this landmark estate appears vulnerable to the full weight of the judicial enforcement process. Consider the precise mandate of the U.S. Marshals Service. When a court finds that obligations remain outstanding, marshals serve as the impartial arm tasked with carrying out those decisions. Their operations remain strictly nonpartisan and administrative in nature. They implement orders that can include taking custody of real estate, requiring occupants to leave, or protecting fiscal interests of the government or judgment creditors. Upon receipt of a valid directive, marshals have no discretion. They must execute it, irrespective of the person's identity or former role. This commitment to neutrality is what lends the current scenario its exceptional character. Ongoing scrutiny from prior special counsel efforts, including those once led by Jack Smith concerning document handling and post office conduct, has continued to exert cumulative pressure on financial and compliance issues. Experts in the law emphasize that the core issue here centers on upholding court directives, not on any underlying political agenda. Nevertheless, representatives close to the president have categorically rejected claims of imminent action against Mar-a-Lago, describing them as unfounded speculation. What makes this development carry such wide implications? Should a sitting or former president face compelled departure from private property via federal officers, it would etch a new precedent, rippling through domestic political dynamics and global views of American governance. Allies would likely interpret it as selective pressure. Opponents would frame it as the straightforward execution of equal justice. Judicial authorities would view it merely as fulfilling their constitutional function. At the time of this report, no official eviction or seizure has been executed. No formal public declaration of property action has emerged. Court records and procedural timelines continue to involve sealed elements or active challenges. Yet the deeper principles at stake can no longer be set aside when legal mechanisms extend to figures of the highest prominence. Does this constitute the sternest challenge to date for U.S. democratic norms? Or might it herald an especially unstable chapter ahead? What unfolds the moment enforcement personnel arrive without prior negotiation? Has authorization been granted for marshals to proceed? Whenever a federal judge enters a lawful order, a single dedicated agency bears responsibility for translating legal text into tangible compliance. That agency is the United States Marshals Service, whose jurisdiction is both precisely outlined and notably expansive. The opening element of this evolving situation is clear and compelling. Marshals possess unqualified authority to enforce judicial mandates. No exemptions apply based on position, no informal protections exist, no partisan considerations intervene. As the nation's oldest federal law enforcement entity, their role prioritizes action over deliberation. From the instant a court approves measures involving detention, property management, removal, or administration, marshals form the essential bridge from judicial decision to on-the-ground outcome. This power derives from congressional legislation independent of media narratives. Should a court determine an obligation persists, monetary or otherwise, marshals are empowered to intervene, securing premises, escorting individuals, or overseeing and reallocating assets, all under explicit court sanction. Here the focus shifts from partisan framing to undeniable legal mechanics. Marshals never independently select cases, they hold no electoral role and launch no campaigns. They respond solely to court instruction. Consequently, any indication of their potential engagement signals the critical transition from legal argument to enforced reality, the point where extensions conclude and obedience becomes non-negotiable. For matters of unsatisfied debts, the sequence adheres to a methodical yet firm progression. After exhaustion of appeals or expiration of grace periods without resolution, courts may greenlight recovery actions. Marshals then step in exclusively to implement, not to bargain. Federal statutes impose no hierarchy of treatment, whether the party is a former office holder, corporate executive, elected official, or average citizen. The mandate remains consistent, the directive uniform, the legitimacy intact. This impartial application highlights the gravity of today's circumstances. If marshals are actively positioned or soon to be, the judicial process has advanced from theoretical debate to compulsory execution. A ruling ceases to be suggestive and becomes imperative. That transformation prompts the defining question right now. When judicial authority commands and marshals prepare to act, does any individual stand truly exempt? Enforcement, distinct from politics, forms the bedrock where law acquires binding force in America. Envision the entrance to Mar-a-Lago transforming from an icon of status to a location subject to court-directed oversight. Is it possible for the nation's most recognized private residents to shift ownership or control via established legal pathways? The second primary driver of this narrative is straightforward and unsettling. Mar-a-Lago sits exposed to possible collection efforts tied to lingering financial liabilities. This exposure does not equate to completed action. It confirms only that statutes permit it once prerequisites are satisfied, a crucial distinction. American law provides that upon court validation of a debt and failure to pay by set deadlines, recovery tools become available. These can range from placing liens, mandating sales, to, in limited scenarios, direct appropriation of fixed assets. Beyond a dwelling, Mar-a-Lago serves as an elite club, a political forum, a recognized brand, and a valuable economic resource. Those attributes place it directly in play during enforcement phases. Judicial review of unpaid judgments disregards emblematic importance. It centers on quantifiable value, title documentation, and statutory eligibility for attachment or control. Where ownership clearly ties to the obligated party and defenses are exhausted unsuccessfully, the asset crosses into enforceable territory. This amounts to debt recovery separate from penalty. Authorities stress that outright seizure ranks as the ultimate step, not the opening one. Initial efforts typically accommodate structured resolutions, collateral postings, or alternative asset dispositions. Should those paths close, however, court authority endures without pause. That persistence accounts for the discomfort generated merely by linking Mar-a-Lago to enforcement discussions. Across years, it has embodied safety, elite access, and substantial leverage. Presently, it appears framed in identical objective terms as any substantial holding confronting court mandates. Those supporting the president maintain such an outcome defies logic, a boundary political life should preserve. Counter-arguments hold that authentic legal parity precludes eternal safeguards for any asset. Courts avoid ideological exchanges. They evaluate proof. Does a binding obligation exist? Has compliance occurred? Are statutory criteria fulfilled? Alignment triggers progression. Notably, enforcement rarely begins with abrupt eviction or total closure. It commonly initiates via documented liens, transfer prohibitions, or supervised oversight. Such early measures alone would signify a stark evolution, from stronghold of influence to entity under legal constraint. That evolution fuels the intensity of this dimension. Mar-a-Lago transcends physical structures and acreage. It represents ideals, reputation, and a platform for discourse. Should judicial supervision ever encompass that platform, ramifications would extend nationally and beyond, probing core issues of responsibility, authority, and the constraints on individual power in a rule of law system. Thus, the persistent inquiry remains, when judicial weighing pits a binding order against a coastal property framed by tropical landscape, do symbolic elements prevail, or does statutory requirement deliver the decisive verdict? That question explains the worldwide scrutiny. What follows if converging pressures intensify from varied sources? Has the cumulative effect of prior inquiries pushed matters toward a decisive edge? The third key component propelling this account holds evident significance. Prior investigative streams, including those directed by Special Counsel Jack Smith, have steadily amplified surrounding legal obligations. This transcends isolated litigation. It reflects integrated efforts by an appointed prosecutor bound to examine high-stakes national issues absent partisan influence. The operation advances with measured care, rigor, and intent, crafting positions built to endure thorough examination across tiers. This structured methodology underlies perceptions that overall constraints are progressively strengthening. Those efforts proceed across several simultaneous avenues: potential criminal accountability, timeline mandates, monetary sanctions, and adherence requirements. Though seemingly discrete, they collectively impose escalating limitations via successive documents, adjudications, and rebuffed requests. Informed observers highlight a vital insight. Constraint accumulates not merely from end judgments, but frequently through the procedural accumulation itself. Required court attendances demand time. Document replies incur expense. Challenges necessitate financial commitments. Unresolved amounts call for settlement. Concurrent proceedings generate inherent compounding momentum. The Special Counsel's Office holds no direct involvement in asset recovery or payment collection. That responsibility rests with judicial and enforcement entities. Its charge involves pursuing evidence-based accountability wherever it leads. Outcomes from that pursuit, however, inevitably intersect with broader personal circumstances: economic standing, public image, private concerns. This intersection lends weight to the notion of intensification. As matters progress from preliminary evaluation through charging phases to preparatory hearings, practical and perceptual burdens mount. Tactics that previously gained postponements now confront narrower judicial tolerance. Schedules firm. Alternatives contract. Parallel civil liabilities, fines, and securities continue independently, producing multiplicative strain. Advocates for the president characterize the approach as excessive, suggesting overextension of authority with implied bias and targeted emphasis. Detractors see faithful discharge of the mandated role, following evidence without regard to status and deferring conclusions to judicial resolution. Undisputed is the concrete weight of accumulating requirements. Each submission imposes response duties. Each adjudication yields outcomes. Each adverse resolution generates added financial and operational loads. As loads compound, enforcement edges toward inevitability. This sequence illustrates how sustained scrutiny, absent ultimate closure, can fundamentally recast circumstances. It modifies risk profiles. It modifies negotiating positions. It modifies evaluations of viability and resilience. Force arises from the accumulating docket itself, independent of public pronouncements. That directs us to the pivotal question anchoring this aspect. When investigative scope broadens, timelines converge, and judicial forbearance exhausts, does historical standing still afford protection, or does the apparatus proceed without limitation? That accounts for sustained focus on incremental progress, escalating tension, and persistent international observation of subsequent steps. Consider if current trajectories enter the historical ledger as inevitable developments no individual can arrest. Has the nation arrived at an unforeseen threshold? The fourth fundamental strand addresses the source of widespread apprehension, actions of unprecedented scale directed at a figure who has held, and now holds, the presidency. This diverges from established patterns. It diverges from ingrained expectations. That divergence imparts its importance. No comparable instance exists in living memory where an individual with presidential tenure has encountered legal exposure of equivalent breadth, visibility, and immediacy. Probes, allegations, financial impositions, and prospective enforcement converge in singular fashion. America's founding rested on equal application of justice, yet it also incorporated tacit understandings that historically buffered former presidents from overt judicial engagement. Those understandings now collide with concrete application. This dimension surpasses any specific litigation. It entails breaching an uncrossed boundary, deploying routine instruments such as demands for testimony, financial securities, penalties, and enforcement potential against a former and current chief executive. The landscape becomes uncharted. Scholars of constitutional design describe it as a profound stress test of institutional endurance. Those aligned with the president perceive risk. They contend that countenancing such measures against an ex-president or sitting one invites future misuse of legal tools for partisan advantage. In that lens, the moment signals escalation rather than equity. Opposing perspectives reverse the assessment. Refraining would entrench preferential status, conferring enduring immunity on office holders. In that lens, proceeding signals not retribution but belated parity. Courts eschew abstract discourse. They deliver directives, and directives compel adherence. Absent precedent, practice assumes primacy. Judges recognize rulings today will face enduring scrutiny. Prosecutors understand proceedings unfold under historical observation. Enforcement bodies appreciate errors could precipitate broad instability. No playbook governs such scenarios. Only applicable statutes, interpreted amid present realities and universal attention, prevail. This transpires amid the president's continued centrality in political life, as leader, voice, and focal point of discourse. That prominence alone heightens consequences tied to each procedural milestone. Markets monitor intently, international partners monitor intently, rival entities monitor intently. The handling of this juncture broadcasts messages globally regarding whether elevated position confers lasting safeguard or whether foundational mechanisms withstand extreme duress. History advances via choices rendered, not assurances awaited. That elevates the paramount question encompassing this strand. When legal process confronts a president openly before a worldwide audience in unprecedented manner, does it affirm democratic robustness or signal foundations under acute pressure? That explains the absence of precedent and the impossibility of retreat. Suppose domestic legal actions propagate effects across international boundaries. Are observers witnessing a core evolution in democratic practice as it occurs? The fifth and concluding dimension carries the narrative far beyond domestic proceedings and tangible holdings. It implicates worldwide political dynamics and the vitality of democratic governance. This has transcended purely national concern. When the preeminent democratic power undertakes vigorous judicial action toward a former and current leader, repercussions diffuse extensively. Allies, adversaries, economic centers, and proponents of self-rule worldwide observe developments with close attention. The reason is evident. Events here recalibrate assumptions universally. Over generations, the United States has modeled democratic operation, impartial justice, and institutional continuity. National elections, judicial functions, and orderly successions have informed, and at times instructed, other systems. Today, the international community poses a sharp inquiry. Can equivalent structures preserve integrity amid challenges of this magnitude? In European governance circles, analysts dissect the case in progress. Successful application of legal standards to a high office holder? Does it bolster democratic integrity or risk normalizing politically motivated litigation? Resolution remains pending, and ambiguity itself exerts influence. Centralized regimes interpret developments as evidence of democratic frailty, proof that even America contends with internal discord and vulnerability. Some invoke parallels to rationalize their own restrictive measures. Conversely, democracy supporters abroad extract an affirming interpretation. No individual enjoys perpetual exemption. Even peak authority submits to legal consequence. That perspective resonates powerfully in those networks. Herein lies the profound tension. Identical facts either undermine faith in democratic systems or reinforce their legitimacy. Economic arenas register influence as well. Assurance in U.S. institutional steadiness transcends concept. It shapes exchange rates, capital movements, security arrangements, and commodity dynamics. Indications of potential volatility, enforcement steps, or systemic friction elicit swift adjustments. Overseas representatives discreetly gauge trajectories. What ensues should judicial imperatives intersect electoral calendars? What ensues should directives encounter coordinated pushback? Such considerations extend beyond the capital to global hubs. Encompassing all is the contest over framing. Online platforms, state communications, and international media advance divergent accounts of the same reality. One emphasizes duty, another highlights inequity. Factual adjudication proceeds live. That contest underscores why this culminating dimension may eclipse predecessors in consequence. Democratic systems rest on more than codified rules. They depend on shared conviction, confidence in uniform application, and institutional capacity to bear load. Should the United States traverse this interval with candor, proportionality, and disciplined conduct, it may reinforce its standing, furnishing renewed demonstration of democratic durability. Should missteps prevail, disarray, polarization, or reciprocal maneuvers, the consequences would transcend national confines. That leads to the ultimate inescapable question. When the principal democratic exemplar submits its foundational commitments to supreme trial, will it establish an international benchmark for accountability or serve as a sobering lesson for societies everywhere?